Mobile Home Rent Review Commission meeting to order. Join me if you would and are able in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Roll call, please.
Commissioner Johns? Here. You need to speak into the mic, please.
Now I'm here.
Commissioner Meekum?
Here.
Vice Chairperson Gomez?
Here.
Chairperson Holbrook?
Present.
Got to be one oddball.
Next item is public comment. This is public comment other than item 2. Do we have anybody? I don't have any slips for that. Also, just want to remind everybody of the social distancing process that we have in place and at the community meeting room. For the public, you guys look like you're doing a good job back there. Thank you. Next item on our agenda is the consent agenda. And asking, is there anybody who wants to remove? We only have one item here, which is the approval of the minutes. Does anybody want to remove that from the consent agenda? We're going to handle it as a normal business process. So I'll take a motion.
So moved.
Second.
I'll second.
Discussion. I think for the discussion point for me, go ahead. No, we're going to have discussion prior to the vote. On the minutes? Yes. I think that the minutes are a little bit lean for me if I wanted to use these as a recall document. They're really well done under the outcomes section of it, which identifies what the commission did, but I thought that they were a little lean under the process part. So for example, Jennifer, there were questions, very specific questions that were asked by commission members that then led those decisions based on those testimonies. So I'm really almost looking for clarification that this has been recorded electronically in the digital world. Facebook has it, so everybody can go back into those logs and find that. We have a stenographer who typed literally every word. How are those pieces put together with these minutes? So for example, if I wanted to use these minutes as a historical document.
Well, the council and the commission, we do action minutes, and that's what you have before you. The council has agreed through our processes that we don't do verbatim minutes. That's why we have a stenographer here. So the minutes that we've always presented have been action. We do have the entire audio of this prior hearing on YouTube. We also have the audio tape on our website. Then we'll have the transcript. So what you are approving is action minutes, which is what we always
So
present
I'm
to the
okay
commission.
once you make the statement that they're available on the city website, that the actual transcripts are available.
No,
on
the
city
video is.
The
The
video
actual
is.
hearing is, but what you're approving is the action minutes.
No, I understand that.
Okay.
I wanted to make sure that they had an opportunity, that the city has control of what's out there versus just, if we leave it in the digital world, people can manipulate the digital world, as you know. So I'm not speaking against the motion. I just need you to understand that. It was a clarification for me. Any other discussion?
You know, I couldn't understand you. I'm sorry.
Cecilia, my issue was that the minutes don't include enough process for me to make a good historical reference. So for example, the minutes simply say person A talks to person B, and that's all they say, with the exception of public comment. In public comment, they actually identify what it is that those people said. So a lot of times when you go back as a historian, and again, my primary job is as an academician, that I like to use minutes as a historical document. So my clarification with city, and the city clarified that effectively, was that these are available. The actual recording of it is available, which would suffice in the historical component. Does that help?
Yeah, so we are voting,
At this point, we're in discussion. We're about to vote for approval of these minutes, which is the motion.
okay.
Other discussion? All in favor? It's actually roll call.
Okay, Commissioner Johns,
Yes,
Commissioner Meekum,
Aye.
Vice Chairperson Gomez,
Aye.
Chairperson Holbrook.
Yes. Thank you. The next is the commission report, and it says here in my notes, and I'm going to call Don Lincoln. Is he available?
Yes.
Good morning, Don.
Morning. Morning, Commissioners. This is the introduction to this part of the rent hearing. On August 25th, this commission held an extensive hearing on the Valley View Mobile Home Park MNOI fair return application. While at the August 25th hearing, the commission decided many issues, including a tentative decision as to the procedure for determining a permanent space rent increase. The commission did not reach a decision as to the award of any additional rent increase based on the applicant's costs and fees, but instead decided to continue discussion of that item to the next meeting. On August 28th, 2020, Dr. Barr sent his third addendum report, which included his calculation of the allowable rent increase based on the commission's August 25th determination that the fair base year 1987 rent for the park was $182.50 per space per month, and the allowance of $3,406 for the applicant's audit costs should be added to the allowable 2018 expense projections previously provided by staff. With these two changes incorporated in the staff MNOI analysis, the allowable permanent rent increase is $60.21 per space per month. So staff recommends that Dr. Barr's third addendum report be made a part of the hearing record. Second, staff has been informed that both the applicant and the residents will ask the commission at this hearing to reopen the hearing for the limited purpose of receiving additional evidence in the form of documents showing the fees applicant paid after the filing of its application, and permitting oral argument limited to no more than 10 minutes for each party, including staff, as to the amount of fees and costs to be awarded to applicant. Staff recommends that the hearing be reopened for the limited purposes requested by the applicant and the residents. Number three, on August 11th, 2020, Mr. Albert, on behalf of the applicant, submitted a letter seeking a grand total of $124,118.53 in fees and costs. Attached were invoices from Mr. Alpert and Mr. McCarthy. Also attached was a spreadsheet showing the division of the $124,000 in fees and costs among the various experts. Mr. Alpert calculated that the $124,000 amortized over 5 years at 7% divided by 62 regulated spaces would result in a temporary monthly space rent increase of $39.65. Based on 75 spaces, the requested increase was $32.77. Assuming that the hearing is reopened on the fees and cost issue, staff recommends that the applicant's August 11th, 2020 letter, including its attachment, be made part of the hearing record. Finally, staff supplemental report. On September 17th, 2020, as part of the agenda package, staff prepared a supplemental report on applicants' costs and fees claim. In its supplemental report, staff set forth its analysis of its of that claim and its reasons for recommending the commission adopt Dr. Barr's analysis, which supported an award to the applicant of a temporary $15.66 per month per space, or a lump sum payment of $790.75 for preparing the application and participating in the hearing process. Alternatively, staff noted that if nevertheless the commission felt it should award applicant additional fees, an alternate approach, which included a factor for the applicant's success percentage, might justify a temporary $20.05 monthly space rent increase for the next 60 months, or a $1,012.84 one-time payment. Again, assuming that the hearing is reopened on the fees and cost issue, staff recommends that the supplemental staff report be made part of the hearing record.
Thank you, Mr. Lincoln. I'm assuming you were referring to the September 11th edition rather than the August 11th edition.
Yes.
Thank you. Commission members?
I would move that we reopen the hearing for the purposes stated by the staff.
Second. Discussion?
I think it makes sense for us to go ahead and do this.
Bill, I want to make sure under your piece that all 4 of the items listed in the recommendation are to be in this motion, which is number 1, we're admitting Dr. Barr's third addendum, reopening for limited comments, that accept Alpert's letter of September 11th, and then review the supplemental staff report. Is that, am I clear on that?
Correct.
Okay. Additional discussion. Roll call, please, ma'am.
Commissioner Johns,
I'm so sorry about the mask. I just don't understand what was being said. I'm following here.
I made a motion to push forward with the staff's recommendation that we reopen the hearing and consider the items.
Go to your mic.
Sorry. All you're voting on now is a motion to reopen the hearing. That's
I
it.
understand now, yes. My answer is yes.
Commissioner Meekum,
Aye.
Vice Chairperson Gomez. No. Chairperson Holbrook.
Yes. So we will now do all 4 of those. I have 2 public comments, one that is just simply entered into the minutes, and the second one is from Tony Slake. Tony, please come to the microphone, and again, you would have 3 minutes to do this.
Can you, just for the record, can you state the issues so anybody who's coming up to speak understands the purpose for reopening the hearing? What are the specific issues they can address their comments to?
Number 1, that we are going to admit Dr. Barr's third addendum report of August 28th, 2020 into the record. Number 2, we're going to reopen the hearing for a limited purpose of receiving additional information in the form of documents showing the fees the applicants have paid, in addition to those fees set forth with the applicant, and permitting oral arguments, which is a maximum of 10 minutes for all 3 parties, as to the amount of fees and costs to be paid by the applicant. Number 3, that we will admit the applicant's additional materials supporting its fees and costs, claims that are set forth in Mr. Alpert's letter of September 11th, 2020, and that we will review and consider the enclosed supplemental staff report and adopt the cost amount set forth in Dr. Barr's analysis of either $15.66 for a period of 5 years, with the residents having the option of paying $790.75 or the $20.05 versus the $1,012.84. Those are the 4 things that we're now doing.
Can I do the mask or keep it on?
If you get close to the mic, you could probably pretty good, Tony.
Sure. Sure.
I've got you on here too, so.
All right. Tony Slake, 33600 Calamasa Boulevard. I believe Bruce Stanton is going to cover this, but I just wanted to weigh in as well. And first off, just within the last few days, the park owner and attorney had submitted an email offering a settlement, and one of the statements in there was that if they would agree to $60 on the permanent rent increase, or within a few dollars of that, that they would settle for $20 on the legal fees. Being that the permanent rent increase did come in at that number, or very, very close to it, I just wanted to emphasize that the recovery on the fees really should not be any more than 20, in fact, less if possible, but it certainly shouldn't exceed that, because they said they would be good with that if they got close to that $60 number, which they did. Also, what I wanted to add on this is the debt service as an expense is not allowed by the ordinance, and any preparation of,
Mr. Slake, that's not within the scope of
are
what
we
they
not
would-
talking about the recovery of the legal fees?
The debt service, oh, okay, go ahead. If you're connecting it to the legal fees, I'm sorry.
Sure, yeah. Being that the ordinance does not allow that, seems to me those fees would be backed out as well as the fees for the alleged past losses, being that those two items were not allowed there. There was no recovery on that. So again, just to reiterate, less than $20, 20 or less on the legal fees, based on the park owner's and attorney's own offer, that number would be good. And I know they'd like to see less than that from the resident side, but certainly should not exceed that. Okay, thank you.
Thank you for your comments. So I'm not sure which order you would like to go in, gentlemen, that we have reopened allowing 10 minutes apiece. So the way we did it at the first meeting was, I think the Alpert went first, and then Staton, and then Lincoln. So just to be fair, let's put Staton first, then done Alpert, or should we do it exactly the same way we did it the first time? Comments?
Since the request is being made by the park owner and they have the burden of establishing the justification, I think they should go first.
Thank you for those wise comments. I'm going to try and do, again, I'm not real good with this technology, so I'm going to try and do both. I will give you 10 minutes. Can you see the little magic lights? I think Mark's trying to give you he's muted and can't talk to you. Oh, okay. So I'm going to try and do the magic 10-minute thing, and I will also be doing it via my piece. So, Mr. Alpert. Mr.
Mark-
Alpert, you need to unmute. We're trying.
Okay, I'm unmuted now. You guys can hear me?
Yes.
Before I start, I have an objection to state. Tony's comments reflected a privileged settlement communication I had with Bruce Stanton. And in fact, there was a heading on the email that made that point. I want to object to him revealing those communications. And you really should not consider, because we are not accepting these lower numbers. I want to make that very clear. And we were willing to do that as part of an overall settlement arrangement, but we're not, since we have to go forward with this hearing, and he should not have revealed privileged settlement communications. Can I get some kind of a ruling striking those comments?
Do you want me to
Sure, add on.
comment on that?
I'd like to hear what you have to say, Amy, please.
Well, if there was a discussion between Mr. Stanton and Mr. Alpert in the form of a confidential settlement communication, then absent the party represented waiving that confidentiality, it should not be part of the evidence that you consider. So no. So
I'd move to
I think
strike.
we should, hold on, I think we should allow Mr. Stanton to respond if he cares to, as to whether there was a confidential discussion to establish the residence side, as I understand it, represents the residents.
I'm happy to do that. It was a privileged settlement communication, and I concur that it should not be part of the record.
So from that perspective, I would recommend you have a basis to it, not consider that the objection is well taken.
Thank you.
Do we move to strike it from the record?
You can do so.
So moved.
I'll second.
A discussion?
Yes.
Roll call, please, ma'am.
Commissioner Johns?
Yes.
Commissioner Johns, I need you to speak into the mic because the people on the live stream cannot hear you.
Yes.
Thank you. Commissioner Meekum?
Aye.
Vice Chairperson Gomez?
Aye.
Chairperson Holbrook?
Yes. Mr. Alpert, continue. Your time is running.
All right, well, hopefully my 10 minutes just starts now. I want to thank you for the opportunity to be heard. We are going to start with a brief presentation by Suzanne Taylor. Thanks.
Good morning, Commissioner Holbrook, members of the commission. Thank you for volunteering your time today. During our August hearing, members of the commission acknowledged the complexity of fitting a nonprofit into a for-profit box, and you saw much of the confusion play out as each party employed their lawyers and experts to find the so-called truth packed away in 1,600 pages of documents. I think you would agree that it is not a meaningful way to resolve a community problem. Nonprofits and cities should work with one another on housing issues, not against one. I submit to you that the nonprofit structure of this park and others is important to the preservation of safe and affordable communities, and all efforts should be made to secure its continued viability. To that end, I am asking the Commission to pass a motion directing staff to request the city to develop a simplified, more collaborative, less expensive process to evaluate the current and future needs of nonprofit-owned communities, something closer to the meet and confer process where the park and its residents were just a few shorts vote of an agreement. Thank you for your thoughtful consideration of this request.
Folks, now I am not going to repeat what Don Lincoln said. He referred to the two methodologies that are discussed in your staff report. What I want to point out is that both of those two methodologies, the $15.66 methodology and the $20.05 methodology, are based on using the costs incurred in the carriage trade rent increase application. And with the larger amount, they added what I would call a contingency fee element to the second $20.66 one. This is important because the analysis that the staff gave you is not an analysis of looking at the actual costs incurred in this case and determining which of those costs are reasonable. And we think it is unreasonable to simply assume that the costs incurred in the carriage trade should be the same as the costs incurred in this case because of the unique circumstances in this case, and a record that you all know is twice as long at least. Now, and I think even some of the commission members commented this is sort of a unique situation. The ordinance and the administrative rules require such a determination. There are 10 factors in your administrative rules that talk about the various things that you need to look at to make this analysis. Staff just kind of skipped over that and went straight to just one factor and applied this contingency fee thing for part of it. That is problematic, again, because you need to follow your guidelines. It's also problematic because the California Supreme Court in Galland has said the costs associated with pursuing a rent increase application are legitimate costs that need to be included in determining a rent increase in order to determine a fair return, as long as they are reasonable costs. So that determination, so the staff has basically skipped over looking at our actual costs and instead said, well, carriage trade should be applied. Now, we thought, well, if that's what staff wants to do, let's look at the city's own costs in carriage trade versus the city's own costs in Valley View. About 3 weeks ago, we sent out a public records request to the city. We made multiple requests to try to get that information, even in some summary form, so we could sort of test this hypothesis from the city's own costs. Is carriage trade the same as Valley View? And we all know that it isn't, but city staff has not provided that information to you, so you can kind of look and see check the validity of this comparison that is central to their calculation of rent increase. Now, if you want to use one of the two methodologies that city staff is presenting to you, we would request that you continue this hearing until such time as you actually have the city's own expenses on Valley View and carriage trade, so you can see from sort of an independent source, is it really reasonable to assume that the costs of this application should be based on the costs of carriage trade? And we think city staff hasn't presented that because they know that it won't help their position. Now, what you should actually do is look at our actual fees and costs incurred in this case and determine if they are reasonable. You should go through all those 10 factors. Now, the staff report does suggest that there are certain claims or positions that are unreasonable, but it doesn't go the next step and allocate cost or estimate costs incurred in presenting those particular claims. If an applicant asks for a large rent increase based on some theory that you think is unreasonable, but that takes up a very small amount of time in the administrative process, then the only adjustment that is proper is a small adjustment to reflect the time incurred. The city's approach is to use some kind of a contingency methodology, which essentially punishes the park owner for trying to maximize the park owner's rent. Well, that is problematic from the First Amendment perspective. It is the park owner's right to petition the government for as large of a rent increase as that park owner feels that he can justify. So long as the park owner is proceeding with reasonable theories and approaches, he should not be punished for trying to maximize the rent increase any more than the residents should be punished for asserting defenses that were determined to not be valid. So in this case, the staff suggests, for example, that the bond financing expenses, which 1/3 of those we included, were unreasonable to include. Well, we continue to believe that it was reasonable to include this bond financing expense because in this particular unique situation of a nonprofit, there was 100% financing through the bonds, and this financing approach was approved by the residents. But let's say even if you think that this approach was unreasonable, if you think back to that hearing, we spent almost no time talking about the bond financing expenses, almost none of it. I look back at the brief that we submitted with our application, and it discussed it in 2 paragraphs, less than half of a page of a 7-page brief. So just simply using some contingency fee based on the fact that the city didn't agree with getting that rent increase is inappropriate. It doesn't follow the law. Now, another issue that there was a lot of discussion about was the borrower administrative.
Mr. Alpert, you have 1 minute remaining, and this 1 minute is the time that it took for your initial piece.
You're not counting the objection?
That's correct. I have given you the time that was allotted
Okay,
in that
well,
objection.
here's the bottom line. You need to look at our actual costs. Our position on the borrower administrative fee not only was reasonable, it was right. It was supported not only by our CPA, it was supported by our bond financing expert, and it was supported by the city's own public financing expert. Those bond fees are also supported by the definition of operating, the mandatory definition of operating expenses in your rent control ordinance. So to say it is unreasonable for us to expect that this management expense that is defined as a management expense it was unreasonable for us to request it is itself irrational.
Thank you for
So
your
look,
comments. Mr. Stanton?
Thank you. Good morning, members of the commission. Thank you for the opportunity to have the hearing reopened so that we can address this important issue. I'm going to try to confine my comments to the purpose for this 10 minutes, which is to address solely the issue of costs. And we start, I think, by looking at the California Supreme Court case authority for this issue, which is the case of Gallant versus City of Clovis. That case was quoted, the relevant part of that case was quoted at page 47 of Ken Barr's report. One of the key words that Mr. Alpert left out of the Gallant case language is the word legitimate. The Gallant case says that the costs cannot be excluded if the expenses are, reasonable and legitimate in terms of seeking legitimate rent increases. This is a very important limitation as well. That is the premise for this entire theory. And of course, the administrative rules that the staff report very capably has recited to essentially flush out those two words in the Gallant case and give them more meaning. I think that the most important factor under the administrative rules is factor number 10, which is the sole factor quoted by Dr. Barr at page 48 of his report. And that's the relationship of the result obtained to the expenses, fees, and other costs that are incurred. Residents agree wholeheartedly with the statement in the staff report that really goes to what I'll call, the fundamental fairness or basis behind these factors. The residents should never be saddled with having to pay for the costs of the park owner tilting at windmills or pursuing failed theories or theories that on their face are not legitimate. And the simple fact here, folks, is this park owner came into this hearing and proffered illegitimate theories on their face, theories that requested amounts that have absolutely no basis in the ordinance, in some cases that are specifically prohibited by the ordinance. And if we go down the list and look at so far what this commission has denied, the past bond cost, the current bond administrative cost, the interest, the $450 to $500 comparable rent argument, the MNOI, the numerous MNOI calculation errors and adjustments that have to be made, we see that this was far from a reasonable or legitimate presentation. And, I was going to object to the fact that Ms. Taylor came to the podium and started asking the commission for, some sort of relief that's not part of our agenda here at all. But then I thought better of it because I think those comments need to remain in the record. And I think they reflect the reality here that this park owner knew coming into this hearing that there's no basis in the ordinance for most of what this park owner is requesting. This really was an application designed to apparently reveal some sorts of flaws and shortcomings in the ordinance. And really, for the most part, the arguments that the applicant made were policy arguments, not arguments based upon the actual language of the ordinance and the regulations. And I think it's very important that this comment today sort of shows that very clearly. So the staff report, I think, very capably, states the residents' concern here that why should the residents be obligated to pay the costs for all of these, forays into the shortcomings of the ordinance and making requests and hiring, a bunch of experts to try to support it when there's just no support. It's just not legitimate. So we agree, the residents agree with the staff report that if you take the total number that was being requested here by the park owner of $234.53. And if we assume that the amount awarded is going to be $60.21, and I'll note for the record that residents do not agree with that number. We do not believe that the commission reached the correct result. But again, for purposes of this argument, I'm not going to re-argue that. But I'm going to accept that number for purposes of the calculation I'm about to give to you. And if you take $60.21 as a percentage of $234.53, which was the total amount requested, the percentage of success would be 25.7%. I calculated that. The staff report calculates that. So if that's the percentage of success, and we look at factor number 10 under the ordinance, which talks about when you're calculating the cost, the reasonable and legitimate costs of the application, that you're comparing essentially you're taking it to a percentage of the success rate that the applicant was able to achieve, then I think that's our number, 25.7%. Now, again, we're not gonna, sit here and, quibble or object to hourly amounts of experts. We could do all that, but you know what, for purposes of this argument, I'm not going to challenge any of the invoices. I'm not going to challenge the very high dollar amounts that the park applicant experts are charging. So accepting those numbers and accepting the $60.21 number, I think here's where we're at, folks. The staff report lays out two possible alternatives for calculating the cost. The first is just accept the original bar report and the potential calculation that he lays out, and it's only a potential calculation, which he finds to be $15.66. Or accept that calculation for the initial costs, and then for the additional recently added costs, take a percentage of 25.7 and add those two together. And that number is $20.05. So we've got $15.66 or $20.05. Residents disagree with both of those approaches. Residents' approach would be a simpler, more basic approach that eliminates the whole carriage trade argument that we just heard Mr. Alpert make, and it's a much more objective calculation. And that calculation would be to simply take the total increase sought, the total awarded, find the 25.7%, take the total cost claimed of $124,118.53, multiply that by 25.7, that gives us $31,898.46. That number again, 25.7% of the total cost claimed is $31,898.46. If you amortize that over 5 years at 7%, dividing by 75 spaces, that's $632 per space and $8.43 per month. And actually $632 would be the total monthly load for that number. So it comes out to $8.43 per month. If you take out the interest, the lump sum payment would be $425.31. So again, in the minute and a half I have left, I just want to run through this calculation. $31,898.46 represents 25.7% of the expenses, amortized over 5 years at 7%, divided by 75 spaces is $8.43. And the lump sum total without interest is $425.31. Those, I believe, are fair and reasonable numbers related to the reasonable and legitimate costs and expenses incurred in pursuit of this application. This calculation is simple. It dispenses with a subjective analysis of comparing CPA fees in one proceeding to another, trying to weight those. And I'll note one very important last comment about Dr. Barr's report. The last thing he said in his section regarding these costs, section Roman numeral 7, was, while this discussion of application costs includes consideration of accounting and so forth, it does not provide projections of how the factors in the rule may impact a determination of the overall application costs, those issues may be addressed after the commission makes determinations. In other words, Dr. Barr couldn't know really how to make the calculation when he did the report because everything that you've decided so far had not been done yet. And remember, this is a temporary amount. It's a pass-through amount. It's not added to the rent base, and it drops off after 5 years. So residents, in conclusion, submit the correct number should be $8.43 per month, or a lump sum of $425.31. Thank you very much.
Excuse me, I have one
Thank you,
brief
Mr. Lincoln.
objection. I have one brief objection to Mr. Stanton's comments. He stated our requested rent increase was a number around $220. In fact, our requested increase was $150. So he has misstated the amount of the rent increase we seek. That's all my comment, and I think that language should be stricken. Thanks.
Well, if I could respond to that, since it's totally inaccurate, the amount of the request was actually $234.53. It's all through the record, Mr. Albert. Your offer to say, we'll take some sort of other option at 150 was not the amount that was requested. So I think the record's clear.
Mr. Lincoln, you have 10 minutes.
Thank you. Here, the applicant is the prevailing party because it did receive a rent increase. And under the Galan case, you cannot arbitrarily exclude administrative expenses unless they're unreasonable. According to U.S. Supreme Court rulings, the most useful starting point for determining the amount of a fee is the number of hours reasonably expended on the litigation multiplied by a reasonable hourly rate. And again, staff, as the residents, are not challenging those particular items. But the Supreme Court goes ahead and says, even if the plaintiff achieves only partial or limited success, the product of hours reasonably expended on the litigation as a whole times a reasonable hourly rate may still be excessive. This will be true even where the plaintiff's claims were interrelated, non-frivolous, and raised in good faith. And they give the example in this Hensley versus Eckerhart case. Had the plaintiff prevailed on only one of their 6 claims of fee award based on the claimed hours, clearly would have been excessive. And in fact, that's what the situation is here. The applicants spent a substantial amount of their time, and in fact, staff had to hire an additional expert because of their claims, particularly on the Bowers administrative fees, both the current year and past year. In an attempt to try and figure out what should be a reasonable amount, because again, they should only be recompensed for reasonable amount. Dr. Barr looked at the 2017 case, Carriage Trade Manor. There were at least some of the same issues raised. There was a question as to what the base year should be. In fact, I believe all the experts and the attorneys were the same in that case for the applicant. Staff believes that sets a reasonable place to start. That year, the total fees which were awarded were $48,424. Adjusting that amount slightly for some minor inflation and also including credit for the time spent on the voluntary meet and confer meeting with the residents. Staff thinks that should be recompensed. Staff submits that the commission should find the reasonable amount of fees to be awarded in this case is what Dr. Barr indicated, $59,306. That would result in a 5-year temporary rent increase of $1,566 and a fixed payment of 90.75. And again, this rewards the applicant for being successful while recognizing that much of the applicant's costs and expenses were spent on rejected claims, such as the current year borrower's administrative fee, the past year borrower's administrative fee, and the 1/3 of the annual debt service. In addition, as pointed out in a report, much of the complexity, and there were additional costs in this case to all parties, was due to applicant attempting to use its nonprofit status to raise claims that proved to be unsuccessful. Further, unlike prior applications and unlike what happened in Carriage Trade, which involved the same experts, here there were several accounting and other errors which required much additional work by both staff and applicant to resolve. Therefore, at least some amount of applicant's time and effort was apparently spent in correcting its own errors. And again, to the extent that the commission believes the applicant is entitled to additional fees, staff has proposed a slightly alternative approach, which would increase the fee recovery, which would result in $20, 20.05 space per month, or a fixed payment of $1,012.84. Staff believes that those two numbers, either Dr. Barr's or the alternatives, are appropriate in this case where the applicant was successful, not completely successful, but was successful in getting a substantial rent increase.
That completes your presentation.
Presentation.
Thank you, sir. Commission member, Amy,
I would suggest you close the public hearing.
I
So moved.
move a second
I
to
second.
close. Go ahead. Comments. Roll call, please. So motion by Meacham, second by Holbrook.
Oh, Holbrook, second?
Can you repeat the motion?
So, yeah, the motion is simply we're going to close the comments, and so now what happens is just totally up to us to have discussion.
Thank you.
Commissioner Johns?
Aye.
Put the mic in front of you.
Aye.
Commissioner Meekum?
Aye.
Vice Chairperson Gomez?
Aye.
Chairperson Holbrook?
Yes. I move to grant an additional temporary rent increase in the amount of $15.66 per month per space for a period of 5 years at an interest rate of 7% per year based on the amortized cost of Valley View for preparing the application and participating in the hearing process in accordance with Dr. Barr's analysis and his report.
I'm sorry, was that a motion?
It was.
Does that also include the lump sum as the alternative?
I was going to do that as
You're-
the second.
okay, sorry.
I was going to do a 1, 2, 3.
I'll second.
Discussion. Hearing none, roll call, please, ma'am.
Commissioner Johns?
Aye.
Commissioner Meekum?
Aye.
Vice Chairperson Gomez?
Aye.
Chairperson Holbrook?
Yes. I move granting the residents of Valley View the option of paying the temporary rent increase representing the costs associated with the application and participating in the hearing process of $790.75 in a lump sum without any payment of interest rather than amortized over 5 years.
Second.
Discussion. Hearing none, roll call, please.
Commissioner Johns?
Aye.
Commissioner Meekum?
Aye.
Vice Chairperson Gomez?
Aye.
Chairperson Holbrook?
Yes. I move that the temporary rent increase that we have just determined shall not be included in the base rent for the purposes of calculating any future rent adjustments, and the amortized amount shall be identified as a separate line item, itemized on a monthly rent invoice.
Second.
Discussion. Hearing none, roll call, please.
Commissioner Johns,
Aye.
Commissioner Meekum,
Aye.
Vice Chairperson Gomez,
Aye.
Chairperson Holbrook.
Yes. Thank you. We now go to item 3. Amy, would you give us an opener on your piece? Members of the commission, this is in your packet. Sorry.
Forgot to tab that one. Can you all hear me?
Yes.
Okay. So we provided you with a draft resolution per your direction at the last meeting, which is attached to my staff report. The resolution outlines incorporates all of the motions that you made at the last meeting. It also incorporates Dr. Barr's supplemental analysis. It's at the very end of the packet, Commissioner Johns. It contains Dr. Barr's supplemental analysis of $60.21, and then it includes blanks at the very end to insert findings on the temporary rent increase that you just acted on through motion. So what I was contemplating was, depending on what actions you took, that you could then, sorry, too many pieces of paper. Formally approve the $60.21 as the increase, and direct staff to take a few minutes, to take a break, direct staff to go and clean up the resolution based on the action you just took with the temporary, come back with that, circulate that to everybody involved, and then have you take a final vote on that resolution itself, because that resolution is what formalizes your decision. Once that is issued, it is then circulated to everybody by the city clerk, the rent administrator, and that becomes the final decision.
So you're recommending that we take a break at this point and allow you to go back and do the work that you just talked about?
Yes, we can do that, and then you can come back and discuss the revised resolution. I don't know if staff had anything to add to that, but that's, my thought is that would be the best way to do it, so we can have that final decision issued today.
So moved.
Second.
I'll second.
Yeah, so Meacham Holbrook. Discussion, Amy, just as you're preparing that, there's one typo in all of this. If you go to page 6.
Just one.
Yeah, well, that I noticed. This on page 6, the second whereas from the bottom. So it has 66 and 2/13%. I'm suggesting that reads 66 and 2/3.
Got it. Okay.
I'm on page 6 of Amy's report, number 6 on the bottom.
Of the agenda, it's page 70.
70, correct. But if you look at the second whereas from the bottom, which it says the base year NOI is 66 and 2/13. It should actually read 2/3. That was just simply a typo. I think what they intended to do was just a typo. So we have any other, go ahead, Amy.
I was just going to say also, if there's anything else in the draft resolution that anybody wants to discuss before we clean up the typo and insert the temporary, this would be an appropriate time.
I would like to add that I thought that it was well done, that it was comprehensive, and that this was, again, part of my initial piece when we took a look at the record, that this document, in its completeness, really spoke to what actually happened in our meeting and the results. So I think you did a really nice job. There are no corrections, comments, other than the one I had.
I agree.
Additional comments, discussions? We're going to vote on the motion. Is that, how long do we need, Jennifer? Half hour? Max?
Maybe 15, 20 minutes?
So let's go 20 minutes. So we're going to take a break for 20 minutes. We're going to have this in front of us and then make a final decision today. So all in favor, I'm sorry, roll call, please.
Commissioner Johns?
Yes.
Commissioner Meekum?
Aye.
Vice Chairperson Gomez?
Aye.
Chairperson Holbrook?
Yes. Ladies and gentlemen, we are adjourned, so we will be back. The big hand hits the 3 on that clock up there. Thank you.
Bruce?
Thank you, Bruce. Ladies and gentlemen, you have in front of you the Mobile Home Rent Review Commission Resolution number 2020-54 with the additions that have been added as a result of today's meeting. If my understanding is correct, Amy, and correct this, the components are actually on page 25, and that they would have those pieces as a result of today's meeting. There were no other changes, is that correct?
Yeah, and I just found typos. Would you like me to explain briefly?
Sure.
Okay, on page 25, under the subsection C, the next paragraph is labeled Romanet 1. That should be indented, and then that just states the reduction in the fees allowable from 124,000 approximately to 59,306, and then identifies that amortizing that over a 5-year period at 7% would, among all 75 spaces, would be $1,566 per month per space for 5 years. The next section that's labeled B should be Romanet 2. And that provides that the commission finds the park owners are entitled to a temporary rent increase of $1,566 per month over a 5-year period, and that includes the 7%. And then subsection C below that should be Romanet 3, and provides the lump sum option totaling $790.75 for any resident who wishes to do so. And then going over to the next page, subsection D is correct, and so is subsection E. And then we provided you with an exhibit A, which has the column D is the adjusted base rent with the 60/21 for each space that's subject to the ordinance. And column E shows the 1566 as the temporary increase for each space subject to the ordinance. So I can answer any questions.
Members of the commission, are there any questions for Amy? I move approval, resolution 2020-54.
Is that a motion you made?
It is in motion.
Second.
Discussion? Roll call, please, ma'am.
Commissioner Johns,
Aye.
Commissioner Meekum,
Aye.
Vice Chairperson Gomez,
Aye.
Chairperson Holbrook.
Yes. Are there any announcements?
Yes. I will not be joining you again. Back in April, I approached Jennifer and told her that it was my desire to resign from the commission for personal reasons. And she said, okay, but I'd appreciate it if you'd hang around for this particular hearing. And I've done that. I fulfilled my obligation. And I wish all of you well. It'll be fun. But as I said, it was for personal reasons, and it has not been easy to do this, even because of the commitments I made other places, but I've stayed with it and we finished. So I thank all of you for your service, and I thank staff.
Thank you, Mr. Meacham. Other announcements? Staff? Amy? Cecilia? Ma'am? Ladies and gentlemen, for all of the people involved in the whole universe that were involved in getting me to read this many pages and to think and to write notes and so on, people digitally, all of our digital people, appreciate all of the time and effort that you have spent on this project. I appreciate it. So I announce adjournment of the Mobile Home Rent Review Commission for September 22nd, 2020. Do we need a motion on that? I don't think so. Thank you, ladies and gentlemen.
Thanks, everybody.